Welcome to the aspirants of the PG Law Set 2023 to my virtual class. Yes, anyone can unmute and read what I posted on the screen? I said anyone can unmute and read what I posted on the screen so that I am with you and you are with me. Both are traveling in the same vehicle to reach to the destination. Okay, let me read it. The Indian Penal Code of 1860, General Principles and General Exceptions, Multiple Choice Questions. The host, Professor Dr. Mohammed Saheb Hussain. Yes, without wasting the time, let me go of today's class, that is the multiple choice question in the IPC. And where I clearly mention the state of Telangana, TSPGLCET-2023 Indian Penal Code, multiple choice question. Be ready to shoot. First question. In criminal law dash says, it is better than 10 guilty persons escape than that one innocent suffer. And who said this quotation? A. Thomas Cook. B. St. Matthew. Option C, Blackstone. Option D, Wellington. Now the shoot among the ABCD, which is the correct and appropriate multiple choice question for the first question. Participants, shoot the correct one. WRONG. It's not the Thomas Cook. Second option. It is not the D, Wellington. The third option is, anyone? It is a Blackstone. The first question, right answer is C, Blackstone. Now the second question. Dash stated it as, I quote, it is better 100 guilty persons should escape than one innocent person should suffer. I am caught. Who said these words? I'm in quotation. A. Benjamin Franklin. B. Roosevelt. C. Thomas Haig. D. Wellington. Participants, anyone can shoot. The right answer. The right answer to the second question is Benjamin Franklin. He said those quotation. The second question, right answer is A, Benjamin Franklin. Now third question, what is the full form BARD, B-A-R-D, BARD in law? Option A, Broward Addiction Recovery Division. B, Bangladesh Academy for the Rural Development. C, Beyond a Reasonable Doubt. D, BARD Artificial Intelligence. Which is the right answer for this question? Multiple choice question. BARD in law. And we have celebrated 162nd birthday of Gurudev Rabindranath Tagore, and he also be known as Bird of Bengal, Bard of Avalanche Shakespeare. And their bard means a poet. But in law, B-A-R-D, bard means beyond a reasonable doubt. Beyond a reasonable doubt. That is the right answer. So the third question, right answer is C, beyond a reasonable doubt. So now feedback, you can see the standard of beyond a reasonable doubt within parenthesis BARD is a common law standard of proof in criminal matters. This standard is exclusively used in criminal or quasi-criminal proceedings. This includes not only adult criminal trials, but also young offender cases, adult sentencing, and certain provincial penal offenses. Yes, the BARD, BARD in law is beyond a reasonable doubt. So this is the thing which I did not know earlier, but I came to know when I was hosting the 162 birthday anniversary of Gurudev Rabindranath Tagore ji. Now the fourth question. Anyone can unmute and read the fourth question? Yes. The fourth question, dash, in his book, the footprints on the sand of crime was of the notion that such a criminals don't have a motive, nor do they gain anything from committing such an act, but they are simply incorrigible. Who said these words? A. DPC Junjunwala, B. DPC Kurian, C. DPC Karanzia, and D. DPC Kulkarni. Shoot among the right answer A, B, C, D for the fourth question. Participants, WRONG is the wrong answer. It is not a DPC Kurian. WRONG wrong. It is not Junjunwala. The right answer for the fourth question is DPC Kulkarni. D is the right answer, the fourth question. Now the fifth question. Criminal liability in India is set up on the maxim dash, the quotation dash, meaning the act itself does not consist of the guilt unless it is committed with a guilty mind. An integral point must be noted that this maxim is considered to be the basic principle of the whole criminal law. Option A, facit actus non rem nisi mensitria. B, facit rem non actus nisi mensitria. C, actus non facit rem nisi mensitria. Option D, actus non facit rem mensit ria nisi. Out of the A, B, C, D, the quotation, the Latin maxim, which is the appropriate among the A, B, C, D? Participants, the right answer is WRONG. It's not the right answer. Next option, WRONG. I'll give the answer. The right answer for the fifth question is actus non facit rem nisi mensitria. That is, C is the right answer, which I highlighted here. So what I highlighted is C, actus non facit rem nisi mensitria is the right answer for the fifth question. Now the sixth question. In the famous case of the Fowler versus Padgett, that is within parenthesis 1978 dash, made a comment that the intent and act must both concur to constitute a crime. Who said? A, Lord Keaton, B, Lord Kingston, C, Lord Kenyon, D, Lord Tennyson. Should the right answer? Click. Yes, you are right. C, Lord Kenyon is the right answer. The C, which I highlighted here, is the right answer for the sixth question. Now the seventh question. Mens rea is of the following degrees. A, intention. 2, knowledge. 3, reason to believe, defined under the section 25 of the IPC. And 4, negligence, defined under the section 52 of the IPC. Now the options. And A, 1 plus 2 plus 3, B, 2 plus 3 plus 4, C, D, 1 plus 2 plus 4, D, 1 plus 2 plus 3 plus 4. Which is the right option? Here I am giving the options. WRONG. Next option. The right option is C. 1 plus 2 plus 3 is right option because I made something wrong in the... No. It is a 2 plus 1 plus 2 plus 1 plus 2 plus 4 is the right answer because number 3 I made it wrong. Here reason to believe defined under section 26 of the IPC, but here I wrote 25 of the IPC. So when you eliminate the 3, 1 plus 2 plus 4 is the right answer. Means C is the right answer. Now 8th question. Anyone can unmute and read? 8th question. Dash was the first writer to use the term actus reus and he defined it as such a result of human conduct as the law seeks to prevent. A, Professor Martha Mino. B, Ruth Craig. C, Prof. Kenny. And D, Prof. Ellis Ferran. Which is the right option among the ABCD. Yes, right. C is the right answer. Professor Kenny is the right answer, which I highlighted here for the 8th question. Now the 9th question. The subsequent element of the crime is the harm or injury or damage induced to the victim and is defined under the section 44 of the IPC as any harm or injury inflicted on an individual illegally in body, mind, reputation or property. Thus, looking at the above definition, it can be deduced that harm or injury can be caused to number 1, an individual, number 2, property, number 3, mind, number 4, reputation. Now options which I given: A 1 plus 2 plus 3, B 2 plus 3 plus 4, C 1 plus 3 plus 4, D 1 plus 2 plus 3 plus 4. Which is the right option? WRONG. Second option. WRONG. I did not change anything. An individual, yes. Property, yes. Mind, yes. Reputation, yes. So the answer is B. 1 plus 2 plus 3 plus 4 is the right answer. 10th question. Match the following terms, part A and the explanation from part B. Part A, part B I have given here. Let me scroll to the next page so that you could see all at one place. Yes, 1, an individual, 2, property, 3, mind, 4, reputation. And here I have given A, cheating, B, defamation, C, homicide, rape, etc., D, robbery, theft, mischief, etc. Now, match the following: 1B, 2C, 3D, 4A, option B, 1C, 2A, 3D, 4B, option C, 1C, 2D, 3A, 4B, option D, 1A, 2C, 3D, 4B. Right option, WRONG. Second option, yes, you are right. C is the right answer. And here I highlighted 1C, 2D, 3A, 4B is the right answer. You can say here, feedback. An individual, homicide, rape. And property, robbery, theft, mischief. Mind, cheating. Reputation, defamation. Now 11th question. It is a quite complex subject to study as an activity that might be considered to be a crime at a certain location may not be an offense elsewhere. For instance, drinking and gambling may not be considered offense when committed in a club. Such a varying description has been characterized by the William Taft as dash. A. Red laws. B. White laws. C. Blue laws. D. Black laws. Which is the appropriate option among the ABCD as for the William Taft? Yes, you are right. It is the blue laws is the right answer. The right answer is blue laws is the right answer for the 11th question. Okay, 12th question. Proof. Professor Edwin Sutherland defined dash as crime which is committed by a person who is having the high social status and also having the respectability which is acquired by him in the course of his occupation or profession. A. Red collar crime. B. Blue collar crime. C. White collar crime. D. Black collar crime. Which is the correct and appropriate wordings coined by the Professor Edwin Sutherland? WRONG is not a red collar crime. Second, not a blue collar crime. The right answer is C. White collar crime. This is the wording coined by the Professor Edwin Sutherland. Now 13th question. The term white collar crime was coined by dash Edwin Sutherland in his 1939 speech entitled The White Collar Criminals and was used as describing a crime committed by a person of respectability and a high social status in the course of his occupation. Now the dash is whether Edwin Sutherland is a psychologist, B. Anthropologist, C. Criminologist, D. Neurologist. Yes, you are right. He is a C. Criminologist. He is a C. Criminologist is the right answer for the 13th question. Now 14th question. The term white collar workers. See, earlier I say white collar crimes. Now I am saying the term white collar workers was coined in the 1930s by Dash, an American writer who referenced the word in connection to a clerical, administrative and managerial function during the 1930s. A white collar worker is a salaried professional, typically referring to a general office workers and management. A. Lord Montague. B. Upton Sinclair. C. Ringwisk. D. Lord Hanna. WRING. Second option. You are right. It is a B. Upton Sinclair is the person who coined the white collar worker. Now the 15th question. Provisions under the Indian Penal Code for the death penalty. The death penalty can be provided for offences under the following sections of the IPC. Number 1, 121. Number 2, 132, Section 3, 194, Section 4, 302. Option A, 1 plus 2 plus 3, B, 2 plus 3 plus 4, C, 1 plus 3 plus 4, D, 1 plus 2 plus 3 plus 4. WRING. The right answer is, I did not change anything. Hence the right answer is D. That is 1 plus 2 plus 3 plus 4. That is the right answer. Okay. Shall I proceed? Say yes. Now the 16th question. Match the following. Here one section 121, 132, 194, 302. And here part B, I made the waging or making an attempt to wage war or assisting in the waging war or against the government of India. Now here 2, giving a fabricating false evidence. Number 3, here abatement of the mutiny. And the D, penalty for the murder. So here 1, 2, 3, 4, I say mismatch. I did not say match, mismatch. Here A, 1 plus 2, B, 2 plus 3, C, 1 plus 3, D, 2 plus 4. The mismatch is 2 plus 3. That is the B is the mismatch. Only 2 and 3 change, the rest of the other things as it is. 17th question. The lawsuit in India where the death penalty is discussed except 2 options. Find the odd man out. Means which case law? Means 2 are wrong, 2 are right. Number 1, Jagmohan Singh versus State of Uttar Pradesh. 2, Jagmohan Singh versus State of Uttar Pradesh. 3, State of UP versus MK Anthony. 4, State of UP versus KM Anthony. Which is the right options? A, 1 plus 2, B, 2 plus 3, C, 1 plus 3, D, 1 plus 4. WRONG. No, second option. 1 plus 3, you are right. C is the right answer. C is the right answer. Means G. Mohan Singh. Jagmohan Singh, State of Uttar Pradesh. And 3, State of UP versus M full stop K full stop Anthony. That is the right answer for the 17th question. 18th question. The phrase hanged to death was replaced by dash after the subsequent amendment in the criminal law for the capital punishment. There is an astonishing story behind this, wherein Jawaharlal Nehru, an eminent lawyer, brilliantly played with the words of the law while protecting his client who was charged with blowing up a British officer's horse carriage. A, hanged until death. B, hanged till death. C, hanged till death. And D, hanged until death. Then which is the appropriate among the A, B, C, D? WRNG. Hang until death. D is the right answer. And D is the right answer. Hang until the death is the right answer. Not hang to death. Okay, now 19th question. In India, under the Whipping Act 1864, whipping was identified as being one of the method of punishment. It was later replaced by the similar Act 1919, which was ultimately abolished in dash, considering this inhuman nature. Options A, 1952, B, 1953, C, 1954, D, 1955. Should the right answer among the ABCD? For the 19th question. Wrong. The right answer is D, 1955 is the right answer. Whipping is abolished. Then 28th question. Looking at the situation present across India, Justice Krishna Iyer in the case of Dash 1980 within parentheses opened his judgment while the following poignant question is a prison term in Tihar Jail, a postgraduate course in crime. And which case law it is decided? A, Kishore Singh, Ravinder Dev, etc. versus State of Rajasthan. B, Ajit Singh versus State of Haryana and others. C, Ramesh Kaushik versus Superintendent Central Jail. D, Puran Chand versus State of Haryana and others. You are right. It is a C. Ramesh Kaushik versus Superintendent Central Jail is the right answer for the 20th question. Now 21st question. Participants, anyone can unmute and read. Presumption of the culpable mental state is a part of dash. A. Section 7C of the IPC. B. Section 8C of the IPC. C. Section 9C of the IPC. D. Section 10C of the IPC. The right answer is presumption of culpable mental state is a part of answer D. That is Section 10C, capital C of the IPC is the right answer. Now 22nd question. Section 10C was used in which of the following cases? A, B, C, D, which I made it. In which of the following cases it is used over there? Section C, 10C, capital C. The right answer for this question is here, which I highlighted here. B, Devamani versus State of Madras 1983 case law. That is the right answer. Now, 23rd question. In which of the following condition a corporation can be prosecuted? Here I have given the option A. If it is a person under the 10 of the Penal Code. B. If it is a person under the 11 of the Penal Code. C. If it is a person under the 12 of the Penal Code. D. If it is a person under the Section 14 of the Penal Code. The right answer is, if I not be mistaken, it is A. If a person with the 10 of the Penal Code is the right answer. Now 24th question. The maxim of law impontia excusat legem is intimately connected with the which maxim of law? A. Lex cogit admissible ad impossibilis, and B. Lex non ad impossibilis, and C. Lex non cogit and impossibilis, and D. Lex actus reus impossibilis. Then which is the appropriate and equivalent maxim for the 24th question? WRONG. The right answer here I am giving is C. Lex non cogit ad impossibilis is the right answer for the 24th question. Now 25th question. Regarding the reasonableness of doubt in which of the following case the Supreme Court indicated that the conscience of the court can never be bound by any rule, but that is a coming itself dictates the consciousness and prudent exercise of the judgment. Reasonable doubt is in simply the degree of doubt which would permit a reasonable and just man to come to the conclusion. Reasonableness of the doubt be commensurate with the nature of the offense to be investigated dash. Letting guilty is not doing justice according to the law. A. Gurbachan Singh versus Satpal Singh. B. Nagar Swastia Adhikari versus Kishan Singh. And C. Ashir Bindu Rai versus Chitaranjan Banerjee. And D. Sajjan Singh versus State of UP. Which is the appropriate answer for the ABCD for the 25th question? Unmute and shoot. Participants. WRONG. The right answer is A. Gurbachan, here which I highlighted here. Gurbachan Singh versus Satpal Singh is the right answer for the 25th question. Now 26th question. The Indian Penal Code 1860 recognized defense in the chapter dash under the general exception. Section dash covers 3 defenses which are based on the presumption that a person is not liable for the crime committed. A. Here I go. Roman 5 section 76 to 106. B. Roman 4 section 75 to 106. And option C. Roman 5 section 77 to 106. And option D. Multiple choice. Roman 4 section 76 to 106. Now shoot the right answer for the 26th question. WRONG. The right answer is D. Roman 4 section 76 to 106 is the right answer. Now 27th question. Before the enforcement of the Indian Evidence Act 1882, the prosecution has to prove that the case does not fall under any exception, but section 105 of the Evidence Act shifted the burden on the claimant. But in the exception, as per the enforcement of the Indian Evidence Act 1882, the prosecution had to prove that the case does not fall under any exception, but Section 105 Evidence Act shifted the burden on the claimant. But in the exception, as per the 105 Evidence Act, a claimant has to prove the existence of the general exceptions in which offenses? A. Offenses. B. Crimes. C. Tort. D. Civil wrongs. Which is the appropriate word? You are right. B is the right answer. In all the crimes, B is the right answer. 105. Burden lies on the claimant. Okay, and 28th question. A mistake of fact under section dash and dash. Options A 75 and 78, B 78 and 79, C 76 and 79, D 77 and 79 of the Indian Penal Code. Which is the a mistake of fact sections? The right answer is 76 and 79. The C which I highlighted is the right answer for the 28th question. Now 29th question. Match the following section part A and the explanation from part B. Part A I have given intoxication, infancy, insanity and accident. And the part B, section 84, section 85, 86, section 80 and section 82 and 83. And options which are like goes like this. A 1A 2C 3D 4B, B 1C 2A 3D 4B, C 1C 2D 3A 4B, D 1B 2C 3A 4D. Which is the appropriate answer? Here WRNG. The right answer is C. That is 1C, 2D, 3A, 4B, which I highlighted here. And you can see the feedback also. Where is the feedback? Yeah, it is here. Yeah, feedback. Accident, section 80. Infancy, section 82, 83. Insanity, section 84. Intoxication, section 85 and 86. Now let us go to the 30th question. Match the following from part A and the explanation given part B. And here also is there the match the following. Now, part A, communication order, and 2, trivials, 3, necessity, 4, duress. And part B, section 81, 94, section 95, option D, 95. And when you can make the match the following, 1D, 2C, 3A, 4B, B, 1C, 2D, 3A, 4B, C, 1A, 2B, 3D, 4C, D, 1B, 2D, 3C, 4A. Now shoot the right answer. WRONG. The right answer is A. 1D, 2C, 3A, 4B, C. Here the feedback. Now the necessity under 81, duress under the 1894, trifles under section 95, communication order section 93. Now 31st question. An excusable act is the one in which through the person had a caused harm and that person should be excused because he can't be blamed for the act. For example, if a person unsound mind commits a crime, he cannot be held responsible for that because he is not having mens rea. Same goes for dash. Number 1, voluntary intoxication. Number 2, insanity. 3, infancy. 4, honest mistake of fact. And options A, 1 plus 2 plus 3, B, 2 plus 3 plus 4, C, 1 plus 3 plus 4, D, 1 plus 2 plus 3 plus 4. Shoot the right answer. The right answer is 2 plus 3 plus 4 because 1, voluntary intoxication. It is not voluntary intoxication. It is host change from involuntary intoxication to the voluntary intoxication. Hence, 1 is not the relevant answer. So, eliminating the 1, then 2 plus 3 plus 4 is the right answer. Yes. 32nd question. Example, if a soldier firing on a mob by the order of his officer in conformity through the command of the law, then he will dash. A, be liable, B, partially be liable, C, partially not liable, D, not be liable. Which is the appropriate answer? For 32nd question, the right answer is D, not be liable. Now 33rd question. A thought Z to be the murderer in good faith and justified by the law, seizes Z to the present him before authority. A has dash any offense. Option A, committed. B, partially committed. C, not committed. D, partially not committed. Answer is committed. Yes, that is the right answer. Am I right? No, not committed is the right answer. For 33rd question, C is the right answer, not committed. Now, 34th question. In Kiran Bedi versus Committee of Inquiry, petitioner refused to depose to the beginning of the inquiry as she believed that she could dispose only at the end of the inquiry in the case of the in case law of the section dash IPC. Which case law section could be applicable in the Kiran Bedi case? A. 77, B. 78, C. 79, D. 80. You are right. Answer is C. 79 section is the correct of the IPC for the 34th question. 35. Suppose M is trying to shoot a bird with a gun, but unfortunately the bullet reflected from the oak tree, causing harm to N. Then M will not be liable by virtue of the section dash of the IPC. A. Section 79. B. 80. Section C. 81. D. 82. You are right. It is a B. Section 80 is the right answer. Section 80 is the right answer for the 35th question. Now, 36th question. In the case of dash, a division bench held that shooting with an unlicensed gun does not debar an accused from the claiming the defense under the section 81 of the IPC, which is decided in the case of A. King Emperor versus Chinnappa, B. King Emperor versus Reddappa, C. King Emperor versus Peddappa, D. King Emperor versus Timmappa. Which is the appropriate answer? Among the ABCD for the 36th question. Answer is King Emperor versus Timmappa is the right answer. Now 37th question. In the case of dash, Patna High Court upheld that if a child who is accused of an offence during the trial has attained the age of 7 years at the time of the decision, the child has attained the age of 7 years can be convicted if he has the understanding, the knowledge of the offence committed by him. It is decided in the which case law among the ABCD? A. Bhola Bhagat, etc. Prabhupada versus state of Bihar. B. Hariram versus state of Rajasthan and other. C. Krishna Bhagwan versus state of Bihar. D. Banaras Singh and Banarasi Singh versus state of Bihar. The right answer is, yes, you are right, C. Krishna Bhagwan versus state of Bihar. This is the right case law which is highlighted here, C. Now 38th question. In the case of dash, the accused Ashiruddin was commanded by someone in paradise to sacrifice his own son, aged 4 years. Next morning he took his son to the mosque and killed him and then went straight to us an uncle, but finding the Chowkidar took the uncle nearby tank and told him the story. The Supreme Court opined that the accused can claim the defense as even though he knew the nature of the act but did not know what was wrong. A. Ashiruddin Ahmed versus the king. B. Yusuf Sheikh and others was the state. C. Hirala and others was the state of Rajasthan and others. And D. Khan Bhai Kurji Duba versus state. I already mentioned the Ashiruddin and hence the right answer is A. Ashiruddin Ahmed versus the king. So 39th question. In the dash, the accused was drunk and fought with the wife. He poured the kerosene and set her on fire and started extinguishing the fire. The court held that the intended cause to cause the bodily injury which was likely to cause death under the section 299, that the 20th and sentenced H under the section 304 of the part 4 of the code. A. Basdev versus state of Pepsu. B. Babu Sadashiv Jadhav versus state of Maharashtra. C. Madhu Nayak versus state of Orissa. D. Savaji Hamant Bankar versus state of Maharashtra. Yes, you are right. The right answer is B. Babu Sadashiv Jadhav versus state of Maharashtra is the right answer for the 39th question. 40th question. A judge passing an order giving the lifetime jail punishment, believing in good faith that the court has jurisdiction, but will not be liable by virtue of this section dash of the IPC. A. 75, B. 76, C. 77, D. 78 of the Indian Penal Code. Yes, the right answer is 78. You are right. 41 question. In the case of the Bishambar versus Rumar 1950, the complainant Bishambara and molested a girl, Natia, Kacheru, Mansukh and Nathu were accused related to the father of the girl. The Chamars were agitated and they determined to punish the Bishambar and Rumal Singh, Fateh Singh and the Balwant Singh intervened and tried to bring their settlement. They collected the panchayat and the complainant was blackened and given the shoe beating. It was found that the court that accused had intervened in a good faith, but the panchayat was having no authority to take such a step. Is the case law of this section attracted in the IPC is A. 79, B. 80, C. 81, D. 82. The right answer is Participants, C 81, and which is highlighted here. 81 is the right answer. Then the 42nd question, C is attacked by a mob who attempts to murder him. He can't exercise his right to private defense and without firing on the mob. In order to save himself, he is compelled to hurt the innocent children while firing to C committed no offense, and he exercised his right by the virtue of the section dash of IPC 104, 105, 106, option D 107. Participant should any the right answer. You are right. C is the right answer. 106 is the right answer. Yes, 43 question. Section 105. Commencement and the continuation of the right of the private defense of the property. The right of the private defense of the property commences when dash. Number 1. Or either the assistance of the public authority is obtained to or the property has been recovered. 3. The right of the private defense property against the dacoit continues so long as the 4. Offender causes an attempt to cause any person death or hurt. Options A 1 plus 2 plus 3, B 1 plus 3 plus 4, C 1 plus 2 plus 4, D 1 plus 2 plus 3 plus 4. No, wrong. WRONG. It is not a D 1 plus 2 plus 3 plus 4 is not the wrong. It is the C 1 plus 2 plus 4 is the right answer, because for 3 I said dacoit, against the dacoit continues. It's not the dacoit, it is against the robbery continues, that I changed it. Now 44th question. Section 105, commencement and the continuance of the right of the private defense of the property. The right of the private defense of the property commences when dash. Number 1, or a wrongful restraint. Number 2, as long as the fear of the instant death, or 3, instant hurt, or 4th, instant personal restraint continues. Options A 1 plus 2 plus 3, B 2 plus 3 plus 4, C 1 plus 3 plus 4, D 1 plus 2 plus 3 plus 4. The right answer is, I will drag it to the next page. Yes, you are right. The right answer is D 1 plus 2 plus 3 plus 4, because I did not change anything. Now 45th question. Which statement is the correct statement among the 4 options? A, B, C, D, which I have given. But here I say the right of the private part intangible, here say immovable, here I say movable, and here say property. But actually it is the property only. That means A, B, C, D, A, B, C is wrong and D is the right answer. Only the property. But I changed the mobile property, immobile property, intangible property respectively into the A, B, C. Now the 46th question. In this case, the police had a warrant against a person. However, at the time of the arrest, he arrested the wrong person. The arrested person filed a complaint. However, the police officer was not held liable. In this was the case of the mistake of fact, and the police officer presumed that he was bound to do so, in which case law it is decided. A. Gopalia versus Kailaya and versus Kailaya versus Emperor, and B. Dhania versus F.L. Clifford. C. Gopala Kailash versus State. D. Dhania Lakshmi versus State. The right answer is WRONG. It is A. Gopalia Kailaya versus Emperor is the right answer. Now 47th question. In this case, the accused was an agriculturist. It was presumed by him that an animal was attacking his field and could
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंधु गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभाशिष मागे गाहे तव जय गा जनगण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे।
सारे जहां से अच्छा हिंदुस्तान हमारा। जय हिंद।